When someone is a mediator for spouses getting a divorce, they cannot later represent either spouse. And that can also happen in the reverse. Sometimes we will be representing somebody and they'll say, oh, my spouse has seen the light, they want to go to mediation, can you do the mediation now? The answer to that really is no, because that's a conflict of interest. You have represented this one spouse, and so you can't then say I'm representing both spouses. It is a conflict ethically, but it's also a conflict as a practical matter, because in my view, the spouse that was not your initial client is always going to feel like you're siding with the other spouse, and that's one thing you don't want to happen during mediation. During mediation, I make my best efforts to make sure that both spouses are heard, that they feel like they're heard, that they feel like there's no bias, and that they are treated in an even-handed manner. And to that end, for my mediation participants, a general rule that I use is that if either party is going to communicate with me, they need to do that in the presence of the other spouse, whether that be physically, on the phone, or by email. So if it were email, they would copy the other side, and so wouldn't my response. If it were by phone, we'd set up a telephone conference, where both could be participants. And obviously, if it's in person, they would both be in the same office with me. There are rare occasions where I feel like it's necessary to speak with one of the spouses individually, and I will do that. I'll ask the other spouse if they're okay with that, have them step out for a moment, and then come back in. And that's only if I feel that I can remove a roadblock that might exist by them being present in the room together. But again, the general way that I like to handle mediation is that both participants participate all of the time.